Honor. Robert Ellman with and on behalf of Smith.
Martina Smith.
Thank you.
Your Honor, after having some conversations with Ms. Smith today, I am moving to withdraw as her counsel due to a breakdown in attorney-client relationship. This also comes at her request.
Is that correct, ma'am?
Yes, I feel that the attorney is not representing me fairly and is taking my life as a game. I just graduated college and
Mr. Ellman?
Yes, sir.
You have got to be kidding me.
If you hear what I hear, sir, and you wouldn't.
Maybe, so you made that determination with your law degree. Oh, I'm sorry, do you have one?
I have a college degree, paralegal.
Yeah, but you don't have a law degree. I'm going to tell you what, ma'am. This gentleman has been appearing before me since the day he started practice. And if you are coming before me and telling me that in meeting with you as a client, that he does not take you seriously, the jeopardy that you may be facing seriously, or do that, I'm going to be honest with you, I do not believe you at all. That has never been the way that Mr. Ellman has conducted himself in this court. And quite frankly, is one of the finest attorneys Washtenaw County has. Now, he may have to tell you things you don't want to hear, but that's his job. And I've never known that man not to do his job. Were you? Didn't even make any sense.
Your Honor, my position is that if she has these concerns about me and my abilities, then we're not going to move forward well together.
Hey, Mr. Ellman, I'm not going to make you stay with somebody that can't appreciate your talents. I'm just not going to do it. I mean, that's going to be her business. Were you appointed on this case?
Yes, I was, Your Honor.
That means the PD had a conflict.
That's correct.
Which means it's got to go back, which means that I'm going to put this over. And for the time being, ma'am, guess what? You don't have an attorney because I'm letting you withdraw. And they're going to have to get me an attorney and you'll be notified as to who they are. So make sure you answer your phone. Probable cause conference will be adjourned. You are discharged from any further obligation.
Thank you, Your Honor.
Mr. Ellman. Probable cause will be adjourned to November 25th, 2025, 9 a.m. Bond will continue. Thank you.
Your Honor, that's it for me today, Your Honor, and thank you for those kind words.
Yep. Another happy customer. I didn't say anything. I don't know why you start crying. I said nothing.
Your Honor, while we're waiting a second, I believe defense counsel is going to approach with a plea form and an advice of rights, in which case I'm going to have to make a quick amendment to it because the plea form? Yes.
Well, and that's fine. And I'm just going to tell you, we've got a problem.
We know what the problem is, Judge. So we'll address it. Yeah. Yes. Oh, thank you.
Okay. So that's the plea, but I'd like to address the bond issue first.
Okay. I know what it is. I've discussed it with my client, Judge. So I know.
Does anybody want to explain? I've got a positive test for cocaine.
That's correct, Your Honor. Judge, there's not really an explanation per se, Judge. I just would indicate to the court, she's dealing with a lot of health issues right now, Judge. I think, again, she's prescribed the opiates. I know that's referenced in there, but she's got a cancer diagnosis, Your Honor, and I think that's she has a appointment tomorrow, Judge, and she is enrolled in outpatient treatment, Judge. So I'm just gonna, if we're gonna take the plea today, Your Honor, I'm just gonna ask the court to maybe refer for a pre-sentence report and let her meet her requirements, and then we'll see if we can deal with all these issues at sentencing. I'm gonna propose that anyway.
So there's this option. I would note that this case is from back in early 2024, March of 2024. And the charged offense of possession of cocaine is the same controlled substance that the defendant is currently using. And that's concerning.
I thought we had, I want to make sure, I thought there was a previous violation.
There was, Your Honor, I believe it was for missed tests and not positive tests, but that's correct.
So she admits to the violation?
Yes, Your Honor, she did not have, other than, obviously they listed opiates. That's not, I don't think the court's concerned about that part, but.
I'm not concerned about the opiate part because at least there's an explanation that some of the.
I've discussed it with her, Your Honor, and obviously she's indicated a lot of pain, and I said that would address the opiates, probably not the cocaine. But she understands that, Judge, but again, she's enrolled in outpatient, Your Honor. Her next appointment is Monday. She just got out of jail after being in there about 10 days, Your Honor, and I understand, and I've told her this could put her right back into jail. So she hasn't given me a whole lot to work with, Judge. I'm just asking the court to consider allowing her to come back for sentencing and, let her do the outpatient and let her go to the oncologist tomorrow. Sorry.
And Mr. Burgess, I certainly understand that. The biggest problem that I have here, though, is that she was missing tests. She's here on a cocaine charge. She takes the test and cocaine's coming up. And
Judge, she knows she's facing, if the court accepts the plea today, she knows she's facing up to a year in the county, obviously, for the charge. So if she comes back with more tests, obviously that's more time. She knows the judge. So.
I'll hold on to the plea form, Mr. Reynolds, and we'll take her plea next week. And I'll make sure that at the time of taking her plea, she's clean, because I can't even guarantee right now she's clean. So I'm going to adjourn the probable. Pardon?
I have a serious appointment with my pastor. I just found out the other day. I have an appointment tomorrow to see my specialist. It's a mass tumor. They're trying to see what they're going to do with it, if it's benign or it's full-blown cancer. I promise if you please today, I will not have no more dirties. I will not miss an appointment. I will not do anything. I will be.
Ma'am, you get picked up, arrested on a charge which involves the use of cocaine or possession of cocaine. You come here before me, we put you on testing. You don't do your testing initially.
I forgot.
Then once we get you, I reinstated your bond previously. You get out, and what do? You test dirty. I can't trust you. Defendant's bond is revoked. Defendant's remanded. I'll return this matter to the 13th, 9 a.m.
Please, I can cancel. Please, God. Please. Please. I promise I won't give up. No more dirty, ever.
Yeah.
I will do everything you want. Please. Please, John.
You said a week, Your Honor?
13th.
Please, Judge. I want to
Stephanie Cannon on behalf of Ms. Law. Ms. Law, could you please state your name for the record?
Sandra Law.
Miss Glenn.
I lost her. You did I lost my intern, Your Honor. I'm sorry.
All right, what are we doing on Ms. Law's case?
Well, Your Honor, we are working on the case. She does have a bond violation. The court is well aware of it. We did receive, and I did provide the prosecutor.
Counsel approach.
Yeah, you're right back.
We're back on the record in the law matter.
Yes, Your Honor.
What I'm going to do is, we've had a bench conference in this case. I'm going to adjourn this out 1 week to November 13th, 2025 at 9 a.m. However, on September 25th, she tested positive for cocaine or other drugs, but my understanding is type medication. That's on September 25th. October 1st, she then tests positive for alcohol. So I have those two consecutive tests, or those two tests where she's got something in her system she's not supposed to have. And then I don't have another test from her.
Yes, Your Honor. I do understand that, and I will be providing the court with some medical records indicating that for a very good chunk of this, she was actually hospitalized. But my view of it, in truth and candor, is not indicated for all of it, but for a very good chunk of it, she was hospitalized. And Your Honor, I will do an order for inpatient treatment to see if that'll work for this court.
It may, but at this time, given what I'm seeing, I just put it over 1 week. You can get that information to me, but at this time, defendant's bond is revoked and it's remanded.
Thank you, Your Honor.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Campbell, who is here to my right. Your Honor, we're seeking a brief adjournment. Mr. Campbell has an assessment schedule with the 15th District Sobriety Court that may be informative of this matter as well. That assessment is scheduled, I believe.
Does he have a medical marijuana card?
You have a medical marijuana card?
No. How do we know it?
He does not, Judge.
Mr. Allen.
Is there a bond violation report? May I approach?
Progress report, yes.
Your Honor, I thank you for letting me look at the bond form. Mr. Campbell is I believe he has a medical card that is expired. He reports he does have an appointment this afternoon.
He's also here on 2 charges of OWI with occupants under 16. So he really shouldn't be using any substance. But
yes, Your Honor. I'd ask the court to give him an opportunity to continue testing to abstain from marijuana and allow the court to watch these numbers to the extent that they are positive, continue to drift downwards until they hit 0, which may take a brief amount of I think sometimes up to a month to actually zero out if someone has in fact been using. But I'd ask him to allow him to continue to test and address that.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. This time, given the defendant's violations, his bond is revoked. No, my bail. Thank you.
Thank you. Your Honor, I didn't catch the adjourned date.
The 20th.
Thank you.
Calls the case, People versus Nicholas Chalmers.
Trevor Maybell for the people.
Brian Bowling on behalf of Chalmers is approaching, Your Honor. State your name for the record, please.
Nicholas Chalmers.
Thank you.
Your Honor, I'm asking for an adjournment in this matter. Mr. Mayville and I are working to get a video issue ironed out, which I think we've resolved.
You think you
We just need to get it over to my office.
got it?
And then I'd like to address bond if I may.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. Yes, as to bond.
Your Honor, my understanding, the current bond in this matter is a $10,000 bond that was set when Mr. Chalmers missed court back in early October. He's been in custody for 9 days since surrendering himself on that bench warrant. He does reside in Ypsilanti with his grandmother. His mother's here in the courtroom today to provide support to him. He does have a 5-year-old son, and he does work at FedEx. He's hoping that job will still be waiting for him when he leaves custody, whenever that is, hopefully today. I'd ask you to consider reinstating the personal bond that was originally set in this matter. If no objection to a tether, if you feel that that is appropriate.
Why did he miss this court date?
I got the days messed up. I'm sorry, Your Honor.
That sounds like a FedEx issue. Got the days messed up.
Yeah.
And he came back into custody because he turned himself
He
in.
did turn himself back in, Your Honor, to his credit. And like I said, he's been in custody for 9 days since then. I'd ask the court to give him another chance. This is the 4th PCC. To my knowledge, he had appeared for all prior ones prior to the one in October. And he's here today.
Yes, he is. Thank you, Mr. Bowman.
You're welcome, Judge.
Sponsoring the people.
Under the circumstances, I'm not objecting, Your Honor. The defendant has a very limited criminal history. However, what is on there, though petty, is from out of county and shows failure to appears on both of those files as well in its past. So I just wanted to make a note that eventually the courts are going to start taking note of that, but no objection.
All right. I'll reinstate his previous bond, but he cannot be released without a GPS locating.
Wonderful.
Tracking.
Thank you, Your Honor.
You understand that, sir?
Yes, I do, Your Honor.
I'm just going to tell you this. I'm doing this, and I dare you not to show back up. Understood?
Understood.
All right. You do that.
Thank you.
Thank you.
Thanks, Judge.